This next panel is unique at Securities Enforcement Forum West. Instead of looking at the issues through the lens of a specific regulation or enforcement program initiative, we're looking through the lens of industry, specifically the complex world that is Silicon Valley. So let's get started with our moderator, John Hemann, partner at Cooley in San Francisco. John's a renowned trial lawyer with more than 25 years of experience in the securities and white-collar area, and he previously served as chief of the Special Prosecutions and National Security Unit and deputy chief of the Criminal Division in the Northern District of California. Welcome, John.
Thank you.
Very pleased to next introduce Melinda Hague, a partner at Weiss. Melinda will go down in history, of course, as the keynote speaker of the very first Securities Enforcement Forum West in 2015 when she was the U.S. Attorney for the Northern District of California. Eternal gratitude for that, thank you, which she held for 5 years. And she also previously served for 9 years as a federal prosecutor and was chief of the white-collar section in the San Francisco office. It is always fantastic to have Melinda with us. Welcome, Melinda.
Thank you.
Very pleased to welcome back Jennifer Lee. She's with the SEC, where she's an assistant regional director for enforcement in the San Francisco regional office. She supervises the very types of investigations and matters we'll be discussing today, and is exactly who we need on this panel. So welcome, Jennifer. And finally, very pleased to introduce Eric Poer, a senior managing director with FTI Consulting, where he's co-leader of the Securities, Accounting, and Regulatory Enforcement practice. Eric has basically every credential you can get in the accounting and finance area, from CPA to certified fraud examiner, certified in financial forensics, also accredited in business valuation. So for over 20 years, Eric has used his experience in accounting and finance to help clients in Silicon Valley and beyond. And Eric, you bring a great consulting perspective to this panel. Welcome. Let me turn it over to John.
Great. Thank you.
It's very loud.
I'm very loud. I probably don't need this, but it's obviously been an uneventful 2.5 years, and the thing that people have been thinking about least of all is probably securities enforcement. And so I think we thought we'd start with just sort of talking about sort of what's on the top of people's minds from both a private practice perspective and from an SEC perspective. Just sort of what are the big issues that we haven't really been talking about much for 2.5 years, and what are people thinking about, just to get started?
Sure, I'm happy to start, John. So we in industry, of course, are thinking about what the SEC is thinking about. So we pay, of course, all close attention to what the chairman is saying publicly and what the director of enforcement is saying publicly, and those are obviously become our top of mind issues. And under Chairman Gensler and Director Graywall, of course, they're talking about cryptocurrency, they're talking about SPACs, they're talking about ESG and climate issues, they're talking about insider trading. I will tell you, those are the things we're probably not going to talk about much up here, because there are panels that are specifically devoted to all of those subjects. So we didn't want you to think that we weren't thinking about those things, because we obviously are, with Gensler and Graywall talking about them, but we may touch on them, but we're not going to do deep dives. The other, I will just add one more thing, probably in the topic of we're not going to talk about it, is that the chairman seems to be very focused on conflicts of interest. So it's something that we're thinking about. He's focused on conflicts of interest potentially with respect to SPACs, and he is focused on it with respect to investment advisors. There have been a series of cases against investment advisors recently, with the common theme being conflicts of interest. So obviously that's something that's important to the SEC from our perspective. But then the thing that we are thinking about top of mind, that I will touch on, is our perception, and maybe Jennifer can correct me, or maybe she likes this, that there's a really aggressive approach currently by the SEC, certainly in the statements made by the chairman, the statements made by Director Graywall, and it really feels aggressive, it really feels enforcement-minded, it really feels ambitious. So we're certainly standing up and paying attention after 2+ years of just thinking about pandemics. So they're talking about taking aggressive positions on a on a wide range of issues, and there's some fairly tough talk about crypto being the Wild West. Director Graywall in particular is talking about the fact that, in his view, the SEC needs to restore broken trust in the financial system. They're responding to criticism in public statements that the SEC is taking aggressive positions by saying that although there are new technologies and new investment trends, the principles are the same. That's the kind of standard answer. The SEC is all about transparency and fairness. Unregulated crypto exchanges are just unregulated exchanges. Although ESG is somewhat new, being truthful in disclosures is not new. That's just standard operating procedure. The requirements to keep books and records does not end when people start using WhatsApp and Telegram and other ephemeral platforms in their own phones. That's sort of the SEC response to criticisms and concerns about aggressive positions. So the SEC in particular has taken, in our view, untested positions with respect to cryptocurrency and insider trading. Again, you're going to hear about those on other panels, deep dives, and I'll talk about a few examples briefly. But going outside the case context, what we're seeing, and I'm sure some of you are seeing, is in terms of this aggressive approach, is when we try to engage the SEC on that, that we have a disagreement about these legal issues or whether the facts would support an action against the client, there's kind of a quick pivot to, well, just resolve it. Just resolve it. Don't really want to get in a big discussion about these issues, these novel legal issues, whether the facts support an action. That's something that we've seen increasingly, and so I think we're going to talk about how to engage effectively with the SEC, so we're really grateful that Jennifer's here. Along these lines of aggressive approach, you may have seen that Director Graywall is talking about curtailing the Wells process. He talks about it in terms of efficiency, not involving the top people anymore unless there's a reason to, like a novel issue or some reason to involve top management. Otherwise, the Wells process will be delegated. He's talking about that. Of course, understand the efficiency argument, but that causes concerns for us about having the ability to talk to the SEC about particular cases and whether it's appropriate to bring them. So just, again, we're not going to dive deeply, but some of these novel theories in cryptocurrency, obviously the rules and the laws were not designed for cryptocurrency. The big case, of course, 1946 Howey case in the Supreme Court defined securities, and there was no cryptocurrency at the time. And so obviously the big issues with respect to crypto is whether trading platforms are exchanges and whether the cryptocurrency is a security. So those are just untested because cryptocurrency is so new. So just a few examples. Again, there will be a deeper dive later. The SEC has brought a case against Ripple. I'll just mention it. I can't talk about it because we do represent one of the individual defendants in the case, but you may have read about the Ripple case, and obviously it's hard fought with respect to some of those novel issues. There's also a case settled recently in the matter of Biotics, DBA coin schedule, and that case involved a website that publicized digital token offerings, but didn't disclose that the issuers of the tokens actually paid the website. The controversy is that the SEC did not explain which digital assets were securities in settling that case, and that was kind of an interesting situation where two commissioners issued a public statement criticizing the SEC's failure to provide clear guidance about when digital currencies are securities. There's another case recently in the matter of Poloniex, where the SEC alleged that a trading platform met the definition of exchange. But in that case, the SEC, in settling it, didn't identify which digital assets traded on the platform were actually constituted securities. What the settlement says is that the digital asset, very conclusory way, the digital assets that were investment contracts the digital assets that were investment contracts and therefore were securities. That's how it's handled in the settlement. So again, doesn't give us a lot of guidance along these lines when these cases settle. Another case that settled recently was in the matter of blockchain credit partners, DBA, DeFi, money market. That's the first SEC enforcement action involving decentralized financial technology. And in that case, again, the SEC, in settling the case, articulated a fairly aggressive view of how the digital assets constituted or were securities. And then in February of this year, of 2022, BlockFi Lending settled allegations that its digital asset lending platform violated the securities laws. It's a complicated case. I understand the cryptocurrency panel is going to talk about that, so it's just another one where it's really, in our view, it is cutting edge, it is novel. Interestingly, in that case, the chairman, in responding to criticism about the novelty of it, just sort of dismisses that kind of criticism again and just said that case involved, quote, time-tested securities laws. Nothing new to see here. So, we expect this continued aggressive enforcement and then possibly more litigated cases as a result. There are also novel issues in insider trading that are happening. You just heard the panel on insider trading, so I won't belabor that. And then there's just one other area that we thought we'd talk about are these novel theories and cases involving bond traders, because there was such a recent development. The DOJ and SEC have been pursuing cases against bond traders sort of out of the 2008 crisis, and despite a lot of losses and setbacks, have continued to do that. And the basic allegations are that the bond traders are making misrepresentations to counterparties, clients, portfolio managers, other counterparties, what some may interpret as puffery. Some may question whether it was material, but there have been a series of cases. And on Friday, last week, in the Southern District of New York, there was a case brought by the SEC against a former Nomura trader. His name is James M. It's one of these line of cases, and he was cleared by a jury in SDNY last Friday, despite the fact that he testified at trial and under questioning by his lawyer, admitted that he sometimes misled clients about prices. He admitted that he sometimes pretended that he was negotiating with a fictitious third party. He also admitted he wasn't completely honest with other traders about prices that Nomura both bought debt and profits it could realize. But he said he didn't think he was cheating the firm's clients. He said he told lies to avoid uncomfortable situations. He testified that clients lie too, that clients don't rely on his representations, they're doing their own research, and the jury went with him. So again, that's sort of just the general trend we're seeing is an aggressive approach to enforcement. That's what's top of mind.
So the one of the benefits of having Eric and Jennifer here is that we can sort of focus on like the real practical part of dealing with these issues and these kinds of cases. And so when you hear us defense lawyers articulate these, Jennifer, as aggressive theories and theories that we want to talk to the SEC about before the SEC decides to take an enforcement, when we have the white lie defense, if you will, how do we have those conversations with the SEC in an environment in which it certainly appears objectively that the direction from the commissioners is to be aggressive? How do we interact with the staff at your office level?
It's a good question, John. And before I get myself in trouble, let me say the views I expressed today are solely my own and do not reflect those of anyone else at the commission. And with that, I think, Melinda, you raise a good point and a good observation that I do think the commission is trying to be more aggressive and is more willing to take on broader positions, push the envelope, particularly in areas of unsettled law. And for a lot of the substantive areas that you've identified, they are new and emerging, but I still think the SEC's response is, but they still start within the traditional framework. So for crypto, we're going to be thinking about the Haag analysis. We're going to be thinking about, is there a fraud? For SPACs, climate, ESG disclosures, same thing. We are going to be looking at it from a disclosure framework, and is there a false statement? How material is it? is there investor harm? Same thing for insider trading. It's still going to come back to duty, breach of the duty, trading on the basis of inside information. And so to the extent that the commission is going to be saying, okay, we're going to start with that traditional framework, I do see these new and emerging cases just sort of pushing the boundaries and just seeing if there's nothing telling us we can't do that, then maybe we should go for it. Maybe until a court says this is not okay, we should do it. So ultimately, to your question, John, I think if you want to engage with the staff in terms of legal theories, I think you got to still bring it back to the traditional framework. Maybe there's something in there where it's clear just as a matter of law that something is not material, or it's clear as a matter of law that just one of the elements is not satisfied. I think in the unsettled areas, that's where it's more difficult, because I do think this commission is more willing to push the envelope. Again, these are my views.
And how much do we, as industry lawyers, risk? And I'm interested in both Melinda and Jennifer's thoughts on this. But how much do we risk cooperation credit? Everybody, for as long as I've been a lawyer, corporate lawyers worry about getting cooperation credit. And how much do we risk that when we walk in the door and say, we're going to answer your subpoena to the best of our abilities, and we'll talk to Eric about that in a minute. But we're going to answer the subpoena, we're going to get you documents, but meanwhile, this theory is crap, and we want to engage with you aggressively and persuade you that you really shouldn't be walking down this path.
Right. I see those as being parallel and separate tracks. So I think first step in cooperation is you've got to have a self-report. I just think that that's very important to the commission, and just come forward to the commission and say, there could be some kind of issue here. Whether you actually think it has legs or not, I think is a different issue, but that is step one. And then as you go through the cooperation process, it's really just, what are you doing to make things easier on the commission staff to help them understand the issues, to understand the facts? Are you doing things like providing us with information that is not easy for us to collect, like foreign witnesses, foreign documents? Are you helping explain complex transactions, or looking through metadata, or just doing things that I think, just objectively speaking, would be difficult for a limited enforcement staff to do on their own? So that, I think, is a separate question of engaging with us on issues that you think are important and possibly could convince us this may not be worth our time. So one of the classic issues that I typically see right off the bat is materiality. So let's say a corrective disclosure comes out and the stock price just doesn't really react in one way or the other. That's something I want to know right off the bat. If there are things that you think are clear as day that are just not going to change the dependency of the investigation, I want to know that, because that's important to me too. Every minute that I'm spending on an investigation is a minute I'm not spending on something else.
So there's two issues that I want to follow up on, two separate strands there. One of them is cooperation in terms of providing documents and information, and particularly in the context of the enormous amount of documents and information that is now available to, my phone is now ringing, oddly, my Zoom. It's ridiculous. I can't make it turn off now.
What could be more important than this panel, John?
It's hard to believe, isn't it? This enormous amount of document and information that exists now between communications apps and email apps, and everything that is out there now, Slack, which is my own personal nightmare. And Eric, do you want to talk a little bit about sort of what's out there now, and how, in the context of trying to cooperate with the SEC as a company and trying to get information? Jennifer mentioned, information from other countries and masses of information, and processing that information and getting it to the SEC in a way that they simply can't do it because they don't have enough human beings to process this. What are you seeing in terms of that in the world right now?
Well, in the last 5 years, it's probably been the biggest change. It's enormous amount of information, and it's a big lift. And, I think they have limited resources, not as if they couldn't do it, but I think that's one of the things straight down the middle that you can use analytics and that information to your advantage to give it to them, so they don't have to struggle with it or issue subpoenas for you. Say, we've looked at it, here's the relevant information, help them with that. 5-6 years ago, that might have been one person on an investigative team. I've had 50 data analytics people on a case for 2 years, helping the government understand it's so complicated that, I think they really appreciate it. And, I think lawyers are often, in my opinion, they're very focused on cooperation credit, how much money or time off. Really, I think one of the best things we can do is help it get resolved timely. And, not going down rabbit holes we don't need to because people don't understand the information. Because when you get into that level of information, billions of transactions a day, multiple systems, that can take years, many, many years. So I look at that as, Jennifer mentioned materiality. That's one of the things that I think we can get in there early, talk to them about, share with them. It's fairly agnostic, and it's just part of the modern day playbook. And, the SEC is obviously using limited market data and analytics to bring cases, but companies have vast amounts. So I do think that that's something that people really just need to get in front of, have a plan in place how they're going to deal with that because, then you can provide them the specific information, and I think it's quite useful.
And Melinda, how do you navigate that conversation with the SEC staff in terms of getting them to a place where you feel like their requests are reasonable, number one, and number two, just to be honest, that you're not helping them dig your own client's grave?
Yeah, I mean, it's so case specific and fact specific, but we do need to have those dialogues. I mean, what Eric just described is enormously expensive, right? So not all clients can do that.
Yeah.
And when an investigation is opened and we feel from the outset that it's not rooted in the facts or the law, it's really hard sometimes to persuade the client to spend that kind of money in responding to it. So some can and do and don't bat an eye. Some can't. We have individual clients as well who have a really hard time with that kind of thing. Slack is hard to search, I'm learning.
Yes.
Is Slack hard to search?
It is.
Yeah.
Yes.
Maybe that's intentional.
They're all hard.
I don't know. But it is a conversation that we're having with regulators, just the crushing expense of it. But at the same time, you have to be really careful. The SEC settled a case with JP Morgan recently that is a cautionary tale for everybody. JP Morgan, and this is one of the few they were required to admit, right? It's not a no admit, no deny. And it's a record keeping issue, and they weren't collecting or producing, WhatsApp and Telegram and all that stuff. It's just all those private communications from personal cell phones. I guess the SEC found out about it from counterparties. It wasn't reported by JP Morgan, but they were seeing communications between JP Morgan and others, and that's how it came to light. And then the settlement documents would indicate that the highest level people were communicating in the same way, and in the SEC's view, there was little to no effort to maintain records like that were about work and about which there were record-keeping requirements. So I think JP Morgan paid $200 million, 125 and 75. I think 125 to the SEC, 75 to a collection of states, if I'm remembering correctly. So it's a real cautionary tale. It helps in the conversations with the clients. And the other part of this, and I'm sure many of you have dealt with this, is the intrusiveness that people feel when you're collecting their personal devices and looking at places where they communicate about personal matters as well.
I mean, that is the number one issue. If I'm on one of your cases, I think the days of just an issue coming up, the company doing an internal investigation, and then the SEC waits 8 months for this huge email data dump, I think that's over. And I think one of the first conversations we'll have is just how do you think people at this company are really communicating with each other? What is the reality? Are they using Google Docs? Are they using Slack? It's just nobody is really using email anymore except to say, hey, let's talk about this offline, which is not that useful. So no, you can understand why.
It's not useful to us.
So, but it is, it's disheartening for me on my side when I just don't get answers to those questions, where to the extent that it comes out months later that actually people were using Google Docs, but they no longer exist. I mean, I think that just sets the wrong tone for the investigation, because I want to believe you were getting your arms around this internal investigation. There was some reason for me to wait on the document requests that we're going to be sending to you. And I want to know you're capturing what we would want to see in terms of understanding the transactions and the parties and the various players. So I think that's just my encouragement of just understand how people are actually interacting.
Right, couldn't agree with you more. I mean, we have to do that. We have to do that. It shocks people. It shocks sort of the rank and file when they're suddenly turning over their personal cell phone to have it imaged. It's really something that people should deal with at the outset. Don't communicate about work on your personal device. And then you can avoid this kind of thing. And the JP Morgan case is something we can now hand people and say, this is what happens.
Great. I mean, I will say the bring your own device policy that I keep seeing at tech companies, that is difficult to the extent that months down the road, I'll hear from the issuer, actually, we couldn't, for whatever reason, because of their specific policy, we couldn't collect the employee's cell phone, and there could be messages on there, but who knows at this point. And that's an instance where, again, at the outset, I would prefer that the issuer just call me up and say, we can't get this. You may want to subpoena this yourself. Otherwise, it almost feels like you knew this was an issue, you didn't front it, how should I perceive this issuer? And you never want us to be thinking, either you didn't know about it or you were trying to hide something from me. That's just not the right tone.
So those are questions sort of at the front end of your investigation and collection process. On the back end, how do you navigate the issue of, we know that we have not, we know that we haven't looked at everything because we can't, because there's 8 billion terabytes of stuff. And number two, we've relied on Eric to find everything and give it to us.
It's his fault.
To find what's relevant, to look in the right places, to find what's relevant. How do you get comfortable pulling the trigger on filing, knowing that you've looked at the tip of the iceberg, data-wise, and B, you've mostly relied on Eric and Melinda to decide what it is that you're going to look at because they had to take the first cut?
Right. I think it's got to be an ongoing dialogue in terms of what you think is out there and what you think matters. I don't love hearing, we've assigned 20 contract attorneys to review the emails of these 10 lower level employees. I don't love hearing that, but I would love hearing, we've covered everything that the CEO could possibly have maintained, and these are all the things that we've cataloged. We've done X, Y, and Z search terms. They all seem reasonable. We understand how this person communicates. I think that gives me more comfort because I understand you can't be spending 24 hours of your day also looking at this stuff too. I mean, I think there are limits to an investigation, whether on your side or ours.
Eric, are you finding that the staff is technologically savvy enough to have these conversations with you?
Yes.
And to pull in the kind of, I mean, come on.
Yes.
Most of the time, yeah.
Yeah, definitely. I mean, I think it's what Jennifer said. Listen, we only get our arms around what we can get it around, and to Melinda's point, some company, Wells Fargo has more resources than, a startup. And you can only, apply reasonable judgment, and I think you have to explain to them how you came about that, who you talked to, why you looked at what you looked at. You're never going to cover everything. And there's ephemeral messages that just go away. I mean, but if you learn that those were used, I think, you need to be forthcoming about that. And like I said, from my perspective, it's just about trying to move it along and make sure they have the right information so that we're not in a stalemate of subpoenas and productions. And that's where I think, it can be quite expensive. And then it's totally out of the client's control. That's just going to be a long, and there's, reputational and other things that are quite expensive too. So.
I mean, I also think these issues come up anytime there's a restatement. We're always going to be concerned with what is the proper scope? Have you looked at all the relevant transactions? And I do think, hearing from your perspective, well, there could have been these issues over here in this other subdivision or et cetera, but there's not material. And that's helpful just to know there's a reason not to look at this bucket of transactions, right, even if you know there are pervasive issues elsewhere.
So one of the other things Jennifer mentioned earlier is the importance of self-disclosure. Melinda, sort of, is there a difference in your thinking on self-disclosure when you have a public company that has regular filing requirements and disclosure requirements and a private company that does not have those same filing requirements, in terms of how you make a decision on an early self-disclosure?
Yeah, well, the first thing we look at is whether there's an obligation to disclose under any rubric, under the securities laws, or under anything else, and then that's a no-brainer, and that's easy. Whether to disclose other things is a hard decision. There's a lot of thought and discussion that goes into that. I would say very often a decision is made to disclose. Sometimes a decision is made not to disclose. And I think that if there's not going to be a disclosure, what you have to think about is, if down the road, you have to assume things are going to become known. Can you, in good conscience, stand up in front of a regulator and explain your decision not to disclose, and do you feel good about that? And that's how I think about it. And so, I think about if there's an issue, and again, this is putting aside any requirement to disclose. But if if, for example, the company identified the issue itself, there was no whistleblower or anything like that. The company just realized, we should really look into this. When they start wondering about something, they look into it, they identify the issue, they investigate the issue, they understand the full scope of the issue, they fix it, they remediate to the extent there are any remediation that's appropriate, they put controls in place so it doesn't happen again. They do all the things that the regulator would want you to do. That's a better place to be if a decision is made not to disclose. If you can then stand up in front of the regulator when and if it comes out and say, absolutely, we didn't disclose it, we weren't required to, here's what we did. We basically did all the things you would have wanted us to do.
Talk a little bit, if you could, Jennifer, about where the SEC is now on enforcement with regard to private companies. I think my perception is that there's more of it from an SEC perspective than there ever has been. There was a time that when I was in the Department of Justice, that a lot of those cases were either criminal cases or they weren't cases. And now it seems like a lot of the cases are SEC and DOJ cases with private companies.
Right. I mean, I think our office has brought a couple of private company cases where the founders of each, so one was Ubiome and the other was Headspin, we allege that they engaged in misrepresentations during Series C funding rounds. And there, I think the common theme is that for both private companies, the funding rounds, the underlying fraud and the representations themselves were so egregious that it caused actually catastrophic consequences for the companies themselves. So I do think we're looking at we're not looking at every private company, but to the extent that there are these fraudulent fundraisers, it's really no different from the classic offering fraud. And we're looking at impact, we're looking at investor harm, we're looking at just what exactly happened to this company once the truth came to light. So I think to the extent that, I don't know, there are always going to be fundraisers, but I think to the extent that there's more of just egregious defendants sort of allegedly crossing the line, I think we're going to take a hard look at that. And I think in those cases also, there's more likely going to be some kind of whistleblower coming forward. So that could change the calculus, right, in terms of whether you think about self-reporting or not.
Now that we know that the white lie defense works, the whole thing is going to be
juries.
Different now. Eric, do you see a difference in the way private companies and interact with the SEC and public companies interact from the perspective of actually conducting an effective investigation?
Well, yeah, definitely. I mean, they're just inherently not the same animals. I mean, they've got totally different control structures, totally different rules and laws. So I think it is quite different. What I would say is when Chair White came to Stanford and gave a speech about, as Uber was coming up and we all called it a unicorn as they were getting $1 billion valuation, well, those companies were public. And since she gave that speech, I think one of the reasons we haven't seen more is the stock market tripled from that time to the recent high. Now it's around double. And I think, the tide's going out more. So I actually really believe, and I'm seeing more activity, as you might imagine, more whistleblowers, more employees being upset. There's more down rounds in financing. So as the tide goes out, I think some of these things are going to really heat up. And they obviously just don't operate the same way. So if we hold them to the exact same standards, there's going to be big problems. But I think there's people have shown an appetite to want to do that, but there's not been specific rules as to how that's going to come about.
So we've got a couple minutes left, and we can play Stump the SEC and see if anybody has any questions or if anybody has any grievances about the U.S. Attorney's Office from 6 or so years ago. This would be the time to raise those as well. Does anybody have any questions, comments, thoughts?
We can give you back 5 minutes.
I think we've got just 2 minutes left, right? So we're any concluding thoughts from any of you? Maybe especially Eric, or Eric looks like he's got. I was about to.
Well, one thing we haven't talked about that, as this sort of rescinding of the markets, and it's going to shine light on some problems. I mean, I think non-GAAP disclosures are a big deal. Like, I can't talk about specific cases, but current matters. I mean, there's a lot of activity in that. I think some of it's ESG, some of it's people talking about their business plans. They've just gotten in the habit of storytelling, which is fine, and they were getting funding and things, but now storytelling's over. People want to see action. So I think that's when we come back next year, we're going to see there's a lot of activity in that area.
Does that sound right, Jennifer? Just in terms of what the SEC's focus is with regard to non-GAAP disclosures of all different
Right.
kinds.
I mean, I think we've brought a couple of non-GAAP disclosure cases, and it all just boils down to what is the company telling investors is important to them? Are they telling investors to focus on the non-GAAP disclosures? Are they doing something where they're manipulating what should be in the GAAP disclosures but are really in the non-GAAP? So I think it's always been something that we've been looking at, but to the extent that it's becoming more of a priority, I would say think about self-reporting.
Great. Thank you, guys.
Thanks. Thank you, John.
Great job, panel. Thank you so much. We'll be back in 10 minutes for our next panel.